41, 44 and 84 have been lodged by Liam Kerr. Amendments 41 and 44 appear to add the requirement of a public element or an offence to be committed under sections 3 and 5 of the bill, where the offending conduct takes place in a private dwelling. Amendment 84 is consequential. The public element provided for by Amendments 41 and 44 does not extend to what people in other dwellings may see or hear. So if the words or behaviours are seen or heard by, say, neighbours within their dwellings, in an upstairs or downstairs flat, that would not constitute a public element, which means no stirring up hatred offence would be committed. The public element instead seems to require people in public places, e.g. on a street pavement, to see or hear the words or behaviour before an offence can be committed. Convener, in my view, these are entirely artificial distinctions which fail to recognise that when the offence of stirring up hatred occurs within a dwelling, that does not avoid the potential wider harmful impacts such offences to prevent. For example, damage to local community cohesion, feelings of victimisation by neighbours, the incitement of acts of violence may occur in a dwelling, but the effects can be felt by behaviour taking place in public to the detriment of the targeted group. We must also be very careful of the potential unintended adverse consequences of such amendments. The effect of Liam Kerr's amendments 41, 44 and 84 is that a person using some sort of video, teleconference, internet live stream, chat room function may be able to escape criminal liability if it is not possible to prove that anyone who saw or heard the communication was outside a private dwelling at the time. Amendments 41 and 44 would create an obvious glaring omission in the law by allowing people to continue to stir up hatred from the confines of their own home to a wider audience where that audience was within their own dwellings or even another person's dwelling at the time of viewing. If someone behaves in a threatening or abusive manner or communicates threatening or abusive material with the intention of stirring up hatred, I consider the criminal law should be capable of addressing such behaviour whether it takes place within a private dwelling or out with. As has been recognised by legal and academic stakeholders, the criminal law is often concerned with what goes on inside people's homes, and rightly so. We heard from Michael Clancy at Stage 1 Oral Evidence Committee, and he said, I quote, "There is no sanctuary in that sense for most aspects of the criminal law, and I do not think that there should be a sanctuary when it comes to hate speech." I very much agree with Michael Clancy, and I would urge members to vote against Amendments 41, 44 and 84.
Throughout colloquially the dwelling defence. They seek to provide a defence for words spoken in a private dwelling and which are not overheard by another person except those within. Now, I note again at the outset that a provision of this kind exists in parallel public order laws in England, Wales and Northern Ireland. But the underlying rationale for what I'm trying to do here is twofold. Firstly, a point which was made several times during the committee session, I think including by yourself, Convener. It reflects the fact that this legislation is supposed to be concerned with public disorder, as demonstrated by the title of the bill itself. We can all recognise the risk of public disorder at a rally where feelings are inflamed by rabble-rousing public speakers and where individuals can feel emboldened by being in a large group to commit criminal acts. But the same considerations do not apply in the context of a private family home. The language remains equally reprehensible, if you like, at the public rally, but the risk of public disorder is clearly not present. Secondly, there's a wider argument for protecting private speech in the context of the home. Throughout the debate on these proposals, the committee has recognised there is an inevitable tension between, but also the need to balance, the tackling of hate crime with the vital rights of freedom of speech and expression. The government has been forced into making concessions throughout this whole process precisely because the bill, as drafted, failed to protect our right to freedom of speech. But the lack of a private dwelling exemption is one where no concession has yet been made, but it needs to be. Allowing prosecution for stirring up over private conversations in your own home is a violation of privacy. Crucially, a dwelling defence would not hinder the operation of that offence. Indeed, Lord Brackadale told our committee that, quote, "No suggestion has been made to me that the existence of an exception, a dwelling defence exception, has inhibited the use of the stirring up provision." Now, during the evidence sessions, the committee heard concerns that allegations could be made by individuals after an argument at a dinner party or a similar social event and investigated by the police. It's difficult to establish a case for stirring up hatred offence having been committed in that scenario. And Callum Steele of the Scottish Police Federation also warned us that conversations on contentious issues could be repeated innocently by children in the playground and lead to reporting. The police would have no choice but to investigate, and in building a case for prosecution, they'd have to take witness statements from the others present. Imagine the scenario where if you had a guest in your family home who took objection to something you said, the only other witnesses might be your spouse, your children. Without a dwelling defence, this bill could lead to a ridiculous scenario where parents are censoring themselves in their own homes because they are anxious their children might repeat something they've said out of context. The idea that we are going to empower the police to question children over what a parent said over the dinner table is surely anathema to our democratic values. In summary, Convener, I think the reason for much of the opposition to Part 2 is that it deals with situations in which people have opinions. We may not like them, we may not agree with them, but people have a right to them, and they surely must have a right to express them in their own home. It cannot be the job of the police to investigate private ideological disputes and to use the criminal law to set the parameters of acceptable opinion. I fear it would cause serious harm to the police's reputation with the public if they were forced to investigate things said in the privacy of your own home. And I therefore move and seek support for my amendments 41, 44 and 84.
To say there's nothing new in this bill. In fact, I'll just do it now. There's nothing new in this bill about how the police would engage with the public, how the police would respond to crimes or accusations of crimes, how the prosecution would treat things differently. There's nothing new in here about this. And I have to say, some of Liam Kerr's hyperbole is bordering on nonsense. Quite.
With regard to the private dwelling defence, I have some sympathy for what it is trying to do. But when we're talking about threatening or abusive behaviour, and that not to be prosecuted if it takes place in a private dwelling, I don't think that hits the right balance at all. So it would be okay for you to go into someone's house, say, and be threatened and abused, but not be able to report that as a crime because that defence is there. And that is even more so with the use of social media. If you were carrying out that threatening and abusive behaviour on your Twitter account or something like that, that surely has to not be defendable because it took place in a private dwelling. So that's really all I want to say, and obviously reserve my position on this section for stage 3, because we need to meet the aspirations of those who have real concerns about it. I hope the amendments I will be supporting will go some way to do that.
To the public element that have been spoken about, again, I accept for a number of members, there is a kind of finely balanced judgment in this regard, and I want to give members a reassurance that I haven't dismissed any of those arguments that call for a dwelling defence or a public element. Far from it. I've given it very serious consideration and quite a few sleepless nights thinking about this issue. And I know that often at stage 2, when we debate amendments, as we have done already, we do so on technicalities, on draftsmanship. However, on these amendments in relation to a public element, that is firmly a matter of principle and firmly a matter of policy. You should ask those who have been victims of hate crime, assaulted due to their colour of skin, their religion, beaten up because they're gay, ask them whether they are comforted by the fact that the individual who stirred up hatred against them cannot be prosecuted because they did so in their own home. I think they will receive no comfort from that fact whatsoever. There are serious flaws with these amendments in relation to the public element. Somebody could have 20 friends in their private dwelling. The windows, the curtains could be closed, the doors could be locked, and they could intentionally stir up hatred against people who are Jewish. For example, those 20 individuals then go out and desecrate synagogues, graffiti them with swastikas, and they, of course, would be charged for those offences. But the individual who stirred up hatred and intended to stir up hatred against Jewish people would not be prosecuted. How in any way can that be justified or be seen to be fair? Let's give another example. You could have workmen in your house, a group of workmen doing work in your house. One of them may be Polish, for example, and therefore you stir up hatred with the other workmen in that house. They assault, they attack, they verbally abuse that one workman in your house. But because it was done in your private dwelling, then you cannot be prosecuted for stirring up hatred. That, to me, cannot be right. So I will not add anything else to any of the other amendments, other than to say I firmly agree with the points made by Lord Advocate, as you'd imagine. I would, and I hope that members will support the amendments in my name and reject those that I have and the government has expressed some serious reservation and opposition to.